Equipment Lease Agreement TRL I 2001B, Section 11.1. Event of loss. In the event of that any of the units shall suffer damage or contamination with lesser responsible judgment as evidenced by officers' certificate of the lesser to such effect that confirmed that the officer's certificate of the manager makes repair uneconomical, renders such a unit or unit it for commercial use. 2. These shall suffer destruction where it can structure a total loss, or shall suffer the theft or disappearance with an after responsible for an efforts by the lesser to locate the same for the period exceeding 6 months or if earlier the end of the basic term of the renewal term and then in effect. 3. They shall permit a return of the manufacturer pursuant to any of the patent indemnity provisions. 4. Shall have their tilt thereto them taken appropriated by the governmental authority, agency of instrumental under the power of the eminent domain and otherwise, or 5. Shall be taken requisition for the use of governmental authority or any agents instrumentally thereof of the power of the eminent domain, or otherwise such taking the requisition as for the period that exceeds the remaining basic terms or any renewal term in the effect, unless such taking by the requisition is by a governmental authority, agencies of instrumentally of the Mexico, any of the states thereof, in which case such period shall be the leaser of the period as aforesaid. The 365 days in such occurrences have been hereinafter called by event of loss. The lesser, in accordance with the terms of the section 11.2, shall have promptly and fully inform the leaser, the indenture trustee of such event of the loss. Section 11.2, the replacement of the payment of the event of loss upon the occurrence of the event of loss or the domain or the deemed occurrence or of any of the event of loss pursuant to the section 911, the election to replace the pursuant in section 8.1, the lesser shall have as soon as responsibility practically in the event of within 60 days after the responsible officer of the manager shall have actual knowledge of the occurrence of such an event of loss, election, or to replace the giving to the leaser or the indenture trustee notice thereof. Within the initial notice shall identify the unit involved. Thereafter, within 60-day period following such initial notice, the lesser shall have the giving to the leaser or the indenture trust the second notice to which of the following options the lesser shall elect to perform. It is being agreed that except in the case of the election to replace pursuant into section 8.1b, and in which case the lesser will comply with the provisions of section 8.1b, and the lesser shall fail to give such a second notice of the lesser shall be deemed to have elected to perform the option so set forth in section 11.2.2. Upon the lesser's election to perform under the clause of the 1 pursuant to the above mentioned section notice, second notice, or in the circumstance of the election described in section 8.1b with respect to any of the unit, promptly as the practicable following such election in any event and before the 60th day of the filing of such a second notice or section 8.1b, the election of the lesser shall comply with the section 11.4b and shall convey and cause them to be conveyed of the leaser replacement of the replacement unit to be leased to the lesser here and under such replacement unit to be the same car type with the same and newer model year or otherwise approved by the leaser, which approval shall not be unreasonably withheld, and free clear of all of the liens other than permitted liens in their type of description. Clauses 2 with respect to permitted subleases in the clauses 4 and 7 in the definition thereof, and 2 the fair market value, utility, residual value, remaining economical useful life and conditioning, and at least equal to the unit so replace, assuming such unit is in the condition required to be maintained by the terms of the lease to be as the date of the convenience, and is subject to the currently effective permitted subleases having a remaining of the term of not less than 1 year, provided that if only rail cars and newer age or greater value are available for such replacement, the lesser may on the occasion be resubstituted a railway car with a value closer to or equal to the unit in which the original suffered of the event of loss or replace, or which the which with the resubstitution shall occur within 24 hours of moment 24 months of the original replacement, but if there is no event within the 3-year period immediately preceding the basic term expiration date shall comply with the section 11 as if an event of loss have occurred, provided that also the lessor shall elect the options under the clause that both shall fail to perform the obligation to effect such a replacement under the clause 1 of within 60-day period herein provided for there, and except for in the cases of the failure to perform the election to the replacement pursuant in section 8(1)(b), at the end of the such 60-day period the lessor shall immediately give the leaser and indentured trustee notice of such a failure and specify that the lessor shall pay the leaser of the next succeeding rent payment date in at least 25 days after the ending of the 60-day period, or in the case that supplemental rent to the person entitled thereto in the amounts specified in clauses below and next to succeeding rent payment date, and the lessor shall pay such amounts of the rent payment date, and provided there further that the lessor shall have no right to elect a replacement or resubstitution under the clauses if the time notice of event of loss under section 11(2) above the same time such a replacement or resubstitution is to occur, either A, the A lease defaults pursuant section 14A, 14B, 14G, 14H, the lease event of the default shall have been occurred, and by the continuing B, the sufficient cash amounts shall not have been made available to the collateral agency, such as all amounts that have been required to be applied under the section 3(4) of the collateral agency agreement in order to satisfy the amounts referred to the clause in 1 through 11 thereof inclusive shall have been distributed as specified therein thereby, or to the repayment date which is not less than 25 days, not more than 60 days following the date of the notice of the lessor's election to perform under this clause. 2. The lessor shall pay in cause to be paid to the leaser, and of a case of the supplemental to the person entitled thereto in the funds of the type specified in section 3(5), an amount equal to the stipulated loss amount of each such unit is suffering an event of loss of deemed an event of loss determined as such a rent payment date, all basic rent payable on such a date in respect to such a unit exclusive in any basic rent due to on such a date in respect to the unit suffering of the event loss, and C, an unpaid late repayment premium respectable principals amount of the equipment notices to be paid according to section 210B in the indentured and in all other rent. It's exclusive of any of the basic rent payments of such a date respective to the units suffering the event of loss and date due to the payable here and under, including without limitation accumulated equity deficiency amount within the duplication is the amount of calculated above the late payment interest related thereto, and so that after receipt application of all such payments but without withdrawal from with any reserve account owner participant shall be entitled to the terms of the collateral agency to receive and does receive taking the amount of all payments of basic rent in respect of such a unit and the accumulated equity deficiency amount, late payments, interest, and related thereto, and in other amounts due to the owner and participation understood that the unit in stipulated loss amount such as other sums are paid, there shall not be an abatement or reduction of the basic rent into the account of the event loss. Section 11(3) rent termination upon the replacement of any of the units compliance with section 11(2)(1) and 11(4)(b), but only be replacing the units and not any replacement units upon the payment of all sums required to be paid to the pursuant of section 11(2) in respect of all of any units or units any unit or units the lease term with the respect of the units to the units or units and the obligation to basic rent for the unit and the units occurring subsequent to the date of the payment, stipulated loss amounts, date to the conveyance of the replacement unit, and the unit pursuant to section 11(2) shall terminate, provided the lessor shall be obligated to pay rent for all the rent in respect of such unit and units payable in section 11(2) with any respect such as the payment, stipulated loss, and such a replacement of such a unit and units in the respect of all other units continuing to remain to the lease. 11(4) disposition of equipment, replacement of the unit upon the payment of all sums required to the paid pursuant to section 11.2 in the respect of any of the units and units release will convey to the lesser. The leaser will convey to the lesser to designate all right and lease and interest to the leaser into such unit and units as is where is without recourse of warranty except for the warranty as into the absence of the leaser's liens, and shall execute delivery to the lesser and its designee as the leaser the lesser's costs and expense such as bills of sales, other documents, instruments, and as the lesser or its designee may responsibly ably request to evidence such conveyance as to the separate unit of so disposal so long as no event of the default shall have occurred continuing the lesser its designee shall subject to ensure the rights of subrogation if any entitled to any amounts arising from the such disposition, plus any awards, insurance, or other proceeds, damages received by the lesser to the leaser of the indenture trust, by their reasons such event of loss upon the stipulated loss amounts attributed thereto, and any remainder shall be divided by the the lesser and the leaser as their respective interests may appear. At the spot B, at the time of the prior to any replacement of the unit or replacement unit, the lesser in its own expense will A. furnish the leaser with the bill of sales in respect to the replacement unit substantially in the form delivered in the pursuant of 4.1h a participation agreement. B. cause the lease to supplementally substantially in the form of Exhibit A there hereto and subjects such as the replacement unit into the lease duly executed by the lesser to deliver the leaser. The execution of the appropriate parties is being understood that such execution the lesser will cause the lease supplemental to be filed in recoordination in the same manner as provided by the original lease, supplemented in section 16.1y. The extent of the indenture has been satisfied and is discharged. The leaser shall deliver the possession of the original counterpart, the lease supplemental to the indenture trustee, so long as the indenture shall not have been satisfied, discharged, and cause indenture supplemental substantially in the form of Exhibit A and the indenture for the replacement unit to be delivered in the leaser delivered to the leaser to the indenture trustee for execution, and such execution to be filed by the recoordination in such a same manner within the same time periods as provided for the original indenture supplement in section 16.1 and D, furnishing the lesser with an opinion of the lease. Furnishing the leaser with the opinion of the lesser's counsel, which make general counsel of the Assistant General Counsel of the Trli Sec to the effect that the bill of sales referred to in the clause of A and above constitute the effective instrument for the conveyance of title of the replacement until the leaser and the legal and beneficial title of the replacement units have been delivered to the leaser, and Y, describing all filings, recordings pursuant to the section 16 of the respect of the replacement units. B, the furnishing of owners of participation in the applicable affiliates and the agreement of the lesser to identify the owner participation and its applicable affiliates against any adverse tax consequences suffered as a result of such replacement. They are not otherwise identified under the tax identity agreement. F, the furnished lesser of the engineer's certificate which are made from the employee of the manager's certification as to the utility condition of the model year remaining useful life and required under the Clause 1, Section 11.2. Furnished G, furnishing the leaser and the indenture trustee as the officer's certificate certifying that the replacement unit is fair market value, utility residual value, model year, and remaining economical useful life and condition as the lease equal to or the unit being replaced and is free, clear of all liens and other permitted liens of the type described in Clause 2 with respect to the permitted subleases and in Clause 4 and 7 in the definition thereof. H, furnishing the leaser with an opinion of an independent tax counsel responsible acceptable for the owner participation to the effect of the owner participation should not suffer to the adverse consequences as a result of such replacement. 1, the furnisher of the leaser with its opinion of the independent transportation counsel or in-house counsel for the manager as to the absence of liens of the record within the STB as in the completion of all necessary STB filings disposites with the Registration General of Canada described in section 16.1 of the respective replacement unit, and J, furnishing such a document document evidence as a participant of the lease, or the indenture trustee and the respectful counsel may responsibly request in order to establish consummation of the transaction contemplated by the section 11.4. For all purposes hereof, 1. The lessor shall be deemed to be complied with the requirements of section 11.4b of the date of delivery of to the leaser and the participation of the indenture trustee of the documents and the instruments referred to and foregoing clauses A through J and signed by the lessor or in the council and as applicable and due to the form of required filing and the recording, and such filing and recording shall have been made in such documents, and instruments have been executed delivered by the leaser and the indenture trustees, both of them in timely manner. 2. The placement of the unit shall have been deemed to be transferred to the leaser as such as the date upon such a passage of the title of the leaser of the replacement unit shall be deemed part of the properly leased hereunder, and replacement unit shall be deemed unit as defined herein, and upon the passage of the title the leaser will transfer the lessor as is or where is, and without recovery warranty except for as to the leaser's liens, as all the leaser's rights and titles interest in the replacement unit. Upon such a transfer, the leaser will request in the writing of the indenture trustee execute delivery to the lessor with an appropriate instrument releasing such a replaced unit from the lien of the indenture to the indenture to the lessor shall pay the all reasonable output out of the pocket costs. The lessor shall pay all the responsible out-of-pocket costs, expenses, including responsible legal fees and expenses incurred by the leaser and any participation indenture trustee in connection with the replacement pursuant to 11.4. The lessor further in agreements upon receipts fully signed and counterparts of the lease supplement and indenture supplement referred to in the clause of B, and if applicable, C, if in the first sequence. C is of the first sentence of the section 11.4b, it will be as sole cost and expense such a case such as the documents filled as a recorded manner contemplated by section 16.1 section 11.5 eminent domain. In the event of during the lease terms, the use of any of the units as requisition or the taken by governmental authority under the power of eminent domain, otherwise for the period which does not constitute, in the event of loss, all the lessor's obligations under the appropriate of agreements, including with the limitation of the lessor's obligation to pay all the installments of the basic rent, shall continue for the duration of the requisition of taking. Any amount of the section 11.4 and section 12 will be payable to the leaser shall be deposited in related non-shared payments accounting established under the collateral agency agreement. Section 12, insurance.